Most contractors skim right past the insurance section of a contract. They look at the scope of work, they look at the price, they look at the deadlines, but buried in that contract is usually a page or two that decides something far more important. And I can tell you from experience, this is one of the biggest mistakes I see contractors make. They assume their insurance already covers whatever the contract requires, but many times it doesn't. And when a claim happens, that is when people find out they signed something their policy doesn't actually support. Later in this video, I'm going to show you the one line in these contracts that causes the most problems. It is something that we see contractors overlook every single week. If you're a contractor or a business owner working on projects for other companies, almost every job you take is going to come with some kind of contract. Inside that contract, there's usually a section labeled something like insurance requirements. A lot of people treat that section like boilerplate legal language, something you just sign and move on. But the truth is that section is doing something very specific. It's transferring risk. It is deciding who is financially responsible if something happens on that job. If you don't understand what that section is asking for you to do, you can end up agreeing to responsibilities your insurance policy was never designed to cover, and maybe not, right? So in this section, I'm going to break down three things. First, where these insurance requirements actually show up in contracts. Second, what general contractors and property owners are really trying to accomplish when they include them. And third, the clauses that contractors misunderstand the most. Because once you understand how these sections work, you can protect your business a whole lot better before you ever even start that job. So let's get started. Let's start when these requirements actually live inside a contract. Most contracts will have an entire section dedicated to insurance. Sometimes it's called insurance requirements. Sometimes it's part of the risk management section. And sometimes it's buried inside the general conditions. But almost every construction contract that we see or service agreement has one. So inside that section, you'll typically see several things listed: required policy types, right? Minimum coverage limits, additional insured language, proof of insurance requirements, sometimes deadlines for providing certificates. On the surface, this all sounds pretty straightforward, but they want proof you have insurance. The reason those requirements exist is because the company hiring you is trying to manage their own exposure. They want to make sure that if something goes wrong on that job, your insurance is part of the protection structure. In other words, they want to make sure your policy can step in if a claim happens. So here's where contractors often misunderstand the situation. Easy to do. The contract is written by lawyers, right? Representing the project owner or a general contractor. These lawyers are trying to protect their client, not you, typically, right? Which means the insurance requirements they write may ask for coverage that your policy doesn't automatically provide. That leads to the next question. Why are these requirements written the way they are in the first place? Well, when a project owner or a general contractor includes insurance requirements in a contract, they're usually trying to accomplish two things. First, they want proof that you carry insurance. That's the basic part, right? They want to know that if something happens on the job site, there's a policy in place that will respond. The second thing they're doing is something called risk transfer. So risk transfer means that they want liability to move away from them and onto the contractors actually performing the work. For example, if you're a sub installing something on a building and an accident happens, the contract may require your policy to respond before theirs. This is why contracts often require contractors to name the general contractor or property owner as something called an additional insured. That phrase shows up constantly in the contracts that we review, in the construction contracts. So the reason it exists is because it allows another party to access protection under your policy for claims related to your work. This is normal part of construction contracts, but where problems happen is when the contract language requires coverage that the contractor never actually confirmed with their insurance policy. This leads into one of the most common misunderstandings we see. There are three contract clauses we see that would cause the most confusion, and this is more than anything else, bar none. The first is the additional insured requirements. A contract may say the contractor must name the general contractor and owner as additional insureds. Most policies can accommodate this, but the exact wording matters. Some contracts require very specific endorsement forms, If the contractor doesn't provide the correct one, they technically haven't satisfied the requirement. In the second clause we see a lot is insurance limits. Contracts might require $2 million limit in liability coverage, or $5 million or more. We've seen it 15, 25 million. But the contractor might only carry $1 million. If nobody catches that before the job starts, the contractor, we may be agreeing to limits that our policy doesn't meet, right? The third clause is something called indemnification. Indemnification is a legal concept that essentially says one party agrees to protect another party from certain types of claims. When indemnification language and insurance language intersect, that is where the real exposure can happen, because sometimes the contract expects insurance to support obligations that go beyond what a standard policy covers. That is why reviewing these sections before signing is incredibly important. Let me show you what this can look like in the real world. Let's say a subcontractor is hired to do an HVAC work on a commercial project. The contract requires them to name the general contractor and property owner as additional insureds. The contractor signs the agreement and starts the work. Now imagine that during installation, something goes haywire, something goes wrong. A piece of equipment falls. That failure causes damage to another part of the building. Suddenly, there's a claim. Multiple parties are involved: the property owner, the general contractor, and the subcontractor who installed the equipment. At that point, everyone starts asking the same question. Well, whose insurance responds first? If the contract language and the insurance policy align properly, the coverage structure works the way it is intended. But if the contract required something that was never actually added to that policy, the contractor may discover they agreed to protections that don't even exist right now. So that's where expensive legal disputes start. So as a final lesson, which is why understanding these contract requirements before signing is so important, because once a claim happens, it's too late to put the genie back in the bottle, right? You can't change the paperwork. The biggest takeaway here is that insurance section of a contract is not just administrative paperwork. It is part of the risk structure of the entire project. It determines who carries responsibility if something goes wrong. If contractors skim past that, or your agent skims past that without understanding what it asks for, they may be agreeing to obligations their insurance policy doesn't support. These requirements are really common across the construction and commercial work, but they do need to be understood. Ideally reviewed before the contract is signed, because fixing things before a project begins is always easier than trying to solve them after a claim happens. There is another part of these contracts that creates even more confusion than the insurance section itself. It's something called an indemnification clause. What that clause does is it decides who ultimately pays when something goes haywire on the project. Most contractors do not realize how powerful this clause is.